Welcome to Behind the Bar for June 24th, 2025. The Diddy case is coming to an end. We're going to talk in a minute about what we expect over the next couple of days and maybe week and a half. Before we do, by all means, send in your questions. We've seen a tremendous amount of testimony that has now come to an end. There's lots of questions outstanding about where things are going to go next, what we think is going to happen. By all means, send those in, comments, questions. Derek, tell us where we are. We've got the prosecution is rested. The defense decided to call no witnesses. They filed a motion. Set things up for us.
Here we are. So this is sort of a housekeeping day. There was a bit more testimony from the Homeland Security Investigations agent on the stand. There was some cross-examination by Diddy's defense counsel of the usual sort that we've seen throughout this case, where Diddy's team is trying to add some context to some of these text messages that were going on between Diddy and his girlfriends or Diddy and escorts and so forth. But this was sort of housekeeping is how I think about it. They're trying to get as much of the evidence that they need to get to that jury room to deliberate into the jury box before they rest their case. But the prosecution did that. There was some cross, there was some redirect. They then rested. And to give you a recap of what the testimony has been since this thing kicked off on May 5th, all the way back on May 5th, the prosecution has had testimony for 6 weeks. They've had 34 witnesses. That's included Cassie, former employees, other key figures, obviously Mia testifying under that pseudonym. They have shown the jury over 40 minutes of explicit videos featuring Jane and other...
Imagine how awkward that must be for those jurors to sit next to each other at close quarters with strangers. Watching freak-offs with your headphones on.
With Diddy looking at you with headphones on himself, reliving some of his greatest hits, I guess. There have been flight records showing Jane flying from Los Angeles to Miami for these freak-offs and travel arrangements, invoices paid by either Sean Combs or Diddy from personal bank accounts or from corporate accounts for hotel stays, entertainers. This is all to shore up their case of... the Mann Act, obviously, the interstate transport of the escorts for sexual services, the coercive acts in these text messages that will show that he was forcing these freak-offs upon Cassie and Mia, and generally sort of the RICO stuff, right? They're trying to show...
On the RICO stuff, obviously, you've got the alleged bombing of Kid Cudi's car.
Mm-hmm.
You've got the taking a firearm to the meetup with Suge Knight that never really came to pass or violence never ensued from it. You've got these various acts where they're trying to basically establish that this guy is the kingpin of a criminal enterprise that looks a lot like Tony Soprano.
That's right. So the prosecution gets all this stuff in, and then they say, we're done. Yeah. They have rested. Immediately upon resting, the defense had already indicated, we're not going to call any witnesses of our own. We believe we've gotten far enough in cross-examination. We've poked enough holes in their case. We're not going to call witnesses. We also rest. From that point, the defense then filed what's called a Rule 29 motion, which is a motion for acquittal before sending the case to the jury. This is very commonplace. We've mentioned this before. They're basically arguing that the prosecution has not even made a prima facie case to send to the jury to fact find and determine the sort of ins and outs of the evidence and whether he proved coercion, whether they've proved RICO. They say on its face, this doesn't even meet the level of something that the jury should deliberate. Judge, you should just acquit Diddy.
Yeah, so
These don't work.
Cases are never sent to a jury unless there's enough evidence that a reasonable jury could convict the defendant. Otherwise, the prosecution is found not to have met their evidentiary burden by the judge, not by the jury, by the judge. Obviously, the jury then has to go through and weigh the evidence and determine whether the prosecution proved their case beyond a reasonable doubt. The judge is simply being asked by the defense to rule that the prosecution has not met the minimum necessary sufficiency levels to get a conviction and dismiss. It's filed in basically every criminal case.
You're preserving it for purposes of appeal. You're hoping not to get sued by your client, Diddy, to sue you for malpractice for not filing it. So I don't think they expect to succeed on this. Look, the Southern District of New York has very, very qualified prosecutors. It would be a monumental embarrassment to lose on a Rule 29 motion. I don't see it happen.
Heads would roll, including the U.S. attorney himself. I think we would lose a lot of a lot of faith in the SDNY if that would have happened.
I don't think Judge Subramanian is going to have wasted people's time for 6 weeks and not send it to this jury. I think it's a very, very low likelihood, almost approaching zero. The other major development was, as we expected, Sean Combs confirmed his decision not to testify. This was an interesting colloquy because we don't hear from him. He sits in court every day. There's a lot of reading of his body language and his facial expressions and how he looks at his family coming into the courtroom, how he stares at particular jury members during some testimony. We've heard things like that, but not his voice. And so Judge Subramanian asked, "How you doing?" and just sort of treated him like a human. And Combs replied, "I'm doing great, Your Honor. I've been wanting to tell you thank you. You're doing an excellent job."
I'm not sure I would advise
buttering up the judge a little bit.
I'm not sure as a lawyer I would advise my client to say that, though. When they come and they allege that this judge made a bunch of mistakes, I can see at the top of the prosecution's response to that motion,
not according to Diddy.
Quote, Diddy said, quote, "Thank you, Judge. You're doing an excellent job."
That's right. All these mistrial motions that he's overruled during the course of the case, you're doing a bang-up job. Yeah. Everything good from here. He confirmed that his decision to not testify was made on his own with the consultation of his lawyers. This is very commonplace. You have to tell the judge in open court, "I don't want to testify," so that later he can't say, "They didn't even ask me if I wanted to testify." This is just something that you have to go through procedurally so that down the line, Diddy can't say, "My lawyers prevented me," or "the judge didn't allow me to testify." You get that in open court on the record.
And by the way, these little procedures are all based on years of the evolution of our justice system, where defendants made these claims, right? Sometimes successfully went forward and said, "I didn't even know that I was allowed to testify." Well, the first time that happens, and a court of appeal says, "Well, I'm throwing out the conviction." The next time, you know what the judge does? The judge turns to him and says, "Are you making this of your own free will? Do you understand the consequences of your decision not to testify?" They force the defendant to say yes.
It's a great point. And about the law in general, things are accretive. They build on each other. That's why when I was in law school, they said, look at a step stool. It has so many warning labels on it. Why? Because there are a lot of cases about what types of warnings you have to give people about a step stool.
Lawyers ruin everything.
So now the case, it hasn't been submitted to the jury yet. What is going to happen next, I'll give you a little bit of a timeline. Tomorrow, there is going to be the judge took under submission this Rule 29 motion. Tomorrow, they're going to have what's called a charging conference, where the lawyers are going to come in and argue about what should the jury instructions exactly look like when we send this thing back for deliberations. They'll hash that out tomorrow. There'll be some motions and maybe some stories about that. Thursday and Friday have been blocked out for closing arguments. Each side wants 4 hours. That sounds like just one full day, but in actuality, with breaks and everything, they're each going to need a day. So Thursday and Friday, there could be lengthy presentations. What will those look like? Jason has described to you before. That's where the prosecution is going to build this wall.
This is where cases are won and lost, is in closing. They have to take this evidence, and the judge will hold them to that. They will not be able to say, "You heard a witness testify to X." If that hasn't happened, the judge will, the other opposing counsel will object to that. The judge will sustain that objection. You must keep to the facts that have been submitted through the witnesses and build your argument on top of those. We described them before. I think you came up with the metaphor that these are building blocks in a wall. The prosecution has a wall that it needs to convict, and then the defense is going to try and chip away at that. They don't have witnesses of their own. They haven't called any. So they're instead going to try and take a chisel and a hammer to that wall and try to break it apart.
Jason's right, but that universe is closed. And you see lawyers often will be checking things.
Yes.
As they're asking questions of a particular witness or as they're submitting evidence, they are literally checking off boxes so that they'll have that available to put in their closing argument.
Yeah, and so they have an individual stone, and each individual stone is another piece of evidence. And they're going to walk this jury through each piece of evidence. So they will say, first, we're going to talk about the Mann Act. You heard Judge Subramanian tell you, ladies and gentlemen of the jury, that the elements of a charge under the Mann Act are that an individual brought somebody across state lines for the purpose of illegal sex acts, in this case, prostitution, right? So what do we have? First element we have to prove is that they brought him across state lines. Here we had this witness who testified that Diddy paid for Escort 1 and Escort 2, who were in Maryland at the time, to come to New York for the purpose of a freak-off. We have this witness and this witness and this witness has testified. We have this email from Diddy to Cassie saying, bring this person on this date. Each one of these is a building block to the wall of the prosecution for the Mann Act claim. The next one you have is, we can go under RICO. RICO is the most complicated one, right? You need these predicate acts, these predicate illegal acts.
Arson,
extortion, the bringing firearms to different things, to the cajoling Cassie into continuing the freak offs with threats that he would leak her audio, the videotapes to her friends and family. These are all building blocks that are going to meet the specific elements of the crimes, and those specific elements will be provided to the jury by the judge.
That's right. So at the end of their closing argument, they're going to say, you now have the tools. I've shown you the evidence to meet each of these elements. And that's what the prosecution is going to say. Look at this nice, sturdy wall. Then the defense is going to come up for
Before
4
we get
hours.
to that, I want to ask you something. How much do you think the prosecution is going to try and get into the defense's mind, the jury's mind, that this is just a really bad dude? And we've met all the building blocks, but think about what happens if this guy gets to the street. They can't say that out loud, but that's going to be the inference.
And a very skilled prosecutor will be able to get some rhetorical flourish in there that will indicate this is a man who is a danger to society, that you, the jury, have the power to keep off the streets so that he can't do these acts anymore. Now, they're going to your point, they're going to be contained in some ways. They can't go off the reservation and just start painting him as a generally bad guy. But within the parameters of the evidence that they've gotten in, and they've gotten in a lot, they're going to overwhelm the jury with the sense that you may not know how all this stuff fits into place. We're going to tell you how some of it fits into each of these charges, but they're just going to have a tidal wave. I think they're going to overwhelm them, and their whole approach with this case, with 34 witnesses and all of the summary witnesses and so forth, is to just give them so much to swim in that they couldn't in good conscience believe that we can let this man walk out of court with an acquittal.
Go to the defense. Go to the defense, because this doesn't have to. We don't have to go on a long time. There's no evidence to present. Instead, they're going to just chip away.
That's right. And the defense is going to turn around that rhetoric, and they're going to try to say what they've done with this tidal wave of evidence is proof that they don't have the goods on any one of these things. They're just trying to show you that Diddy's a freak and a weirdo and into a swinger lifestyle, but those aren't crimes.
Right.
And his relationship with Cassie, look at it in its full context. This was 11 years this woman was with him. She was enthusiastic about freak-offs on many occasions. They're going to really hammer those text messages where she says, I'm down to freak off anytime. I think they'll build their whole case largely in refuting Cassie. I think Mia, they have an easier time with saying she was maybe in the relationship to have her rent paid, but that's also not a crime.
The gross illegality is not as present with Mia as it was with Cassie. There was some gross illegality there, but you can upend a lot of that, to your point, by saying that she was in on it all.
She was in on a lot of it.
There's some evidence to suggest that she might have been. Now, what
do they do with the hotel?
We don't want to give we don't want to give short shrift to the idea that a battered, abused woman can sometimes appear to lend consent when they're actually not consenting. We understand that. They just need to get the jury to believe that maybe she was consenting to most of this. The hotel video is brutal. All they can try to do is marginalize it, accept what's there, which is our client did not act in a good way. That was awful. That was monstrous behavior. But he's not on trial for that video. Never forget that. There is nothing that he is being charged with that video has anything to do with. Instead, the prosecution is just trying to basically get you to think that he's a bad dude.
That's right.
You know what? He is a bad dude, but that's not a crime.
That's right. And they really will have to walk this tightrope of not being too insensitive to Cassie, but really trying to save Diddy's hide. And so I think you'll hear on closing argument, they'll be a little bit more forceful about he's not on trial for that hotel video. As graphic as it is and as unfortunate as it was, it's not what you're convicting him over when you go back there.
A couple quick questions. I like Michael Wakefield's question. Is there a possibility that others will be charged after Diddy? Now, not in this case. This case is only about Diddy. But there's been a lot of testimony about illegal conduct. I have wondered if there are state prosecutors lurking in the wings in the case of an acquittal who could bring some charges against Diddy for some of the other stuff. Now, the Cassie stuff is too old, but there was other stuff with Jane especially, right?
Yeah, that's not old.
Much more recently that might rise to the level of a state crime.
I could imagine a close look, especially if he is acquitted or there's a mistrial or in some sense he is not held to account for these crimes. You could see a state prosecutor coming in and saying, I'll take a bite at some of the things that are still within the statute of limitations. I could absolutely see that. I don't think his legal problems go away. Certainly the civil cases don't go away.
No, they don't at all.
And his criminal liability, it's still there for some of them.
And then for third parties, theoretically, I suppose you could see if he had sort of his henchmen doing his dirty work for him.
Now, many of them testified under immunity orders. They expressly in court.
That's very good point. They testified under immunity. Also, much of what they testified to cleaning up after the fact, that sort of thing. Those aren't crimes. It's gross, but
Right.
it's not a crime.
I wonder if those immunity orders, and I'm sort of speaking out loud, the feds, in saying we're getting testimony from you, agree not to prosecute you for anything you talk about on the stand. I'm not sure that extends to state law, but it'd be hard after the fact.
At least they wouldn't be able to use the testimony against them. Otherwise,
Right.
you never could have gotten them to testify. SAS 1000, could this case set any precedent for how celebrity or power dynamics affect criminal accountability? Does this case highlight any gaps or strengths in current laws around sexual misconduct, trafficking, or abuse of power? I feel like I've just been asked a law school exam.
I like this question.
I like a question. It's a very
Yeah.
erudite question. I think ultimately this is not the first celebrity to go to court, right? This case has been really by the book. I think that the OJ case was so outlandish. We probably learned some more lessons from that case
Yeah.
that we had from this. I wonder if the prosecutors could do it all over again, are the different decisions they would make, maybe to call fewer witnesses, maybe, we're going to see how the jury responds to all this evidence.
Yeah, I mean, it's basically, it's a little premature for lessons. I remember after OJ, there were a lot of lessons about how we conduct police investigations, and there was a lot more, DNA got much more sophisticated after OJ. There are a lot of lessons to be learned when the dust settles. Right now, we're in the middle of it, and whether he gets convicted, I think if he doesn't get convicted on all three charges, or there are some gaps where the jury just didn't buy what the prosecution was selling, there will be changes in how they present these cases, which cases they choose to prosecute, because this feels very strong in some sense, but I've always said it feels awkward as a federal case in a lot of ways. RICO feels like more of a mafia thing, and the sex trafficking by force is awkward when you have 11-year relationships.
And by the way, prosecutors will ask the jurors if they're willing to speak with them after the case. 100% they'll ask.
Learn lessons.
The jurors are no obligation to do so, but some will, and they will say, like, what did you think of this evidence? Especially if there's a mistrial or Diddy is acquitted, you're going to want to learn from the jury what you can. And if they say, look, we thought the Homeland Security agent was too much, we thought that it was an abuse of power, the prosecutors will learn from that, and they will adopt changes for the next time.
Absolutely. And I could see maybe some state law changes if people feel like, man, there's a lot of people telling us he's a monster of domestic abuse, but there's nothing we can do about it.
Yeah.
Those old cases where they were silenced, maybe they were in the lifestyle and didn't want to sort of speak up at the time, and they just lapsed. That feels unsatisfying to some people, and I could see legislators jumping on that idea.
Carter, who always writes in with the most personal questions, but asks, what will happen to Behind the Bar when the Diddy trial ends? It's our hope to keep it going.
Good question.
There are tons of legal cases affecting celebrity. Derek and I have actually been doing Behind the Bar. Started it, I think, back in 2016, nine years ago, because I remember we did Trump coming into the White House and the Kim Kardashian robbery.
Did Alec Baldwin recently.
More recently, yeah. So I think we're going to keep it going. We don't know if it's going to be an every week thing, or we're just going to find big trials like this one to have fun with.
Yeah, we have a lot of fun. It's different. It's taken on different shape over time. We'd love to hear some feedback from people. Do you guys like it as when trials are ongoing? Do you like it as a sort of weekly check-in on the legal stories of the week? Let us know, and we're open to some ideas.
All right, guys, thanks very much. We will. There's not going to be any more testimony. What are we going to do? Are we going to keep going with this thing for the next few days? What do we think? We've got tons to talk about, right?
Want to hear about jury instructions tomorrow?
We're going to have jury instructions. Actually, jury instructions are fascinating. Don't get me started. But yeah, there's going to be speculation coming out. There's going to be tea leaves that are going to be read. So we'll do it for you.
Yeah, stay tuned.